Hello, my name is Attorney Masa Sam Foray, and I am founder of the Foray firm with offices in Chicago and in Houston, Texas. And I am back again today to answer all of your Illinois family law questions. So today's question is, my ex-wife won't honor our custody agreement. What can I do? Well, I'll tell you what. Orders are not suggestions and they are not requests. Therefore, they are not optional. And so when you have an order that is signed by a judge and that order is still valid and intact, it is enforceable. And you have every right to go to the courts and ask for your order to be enforced. And I'll get to the specifics of how you go about doing that. But before I do that, also note that custody is always modifiable. If it's been less than 2 years since the entry of your allocation of parental responsibilities, which is what we used to call custody in Illinois, then you have a higher burden to prove to ask a court to overturn a relatively new allocation of parental responsibilities judgment. It's a little harder to do, but it can still be done, especially if you can prove that there has been serious endangerment. That is the factor that you will have to show to the judge by way of evidence, by testimony, by witnesses, that the current custody arrangement poses serious endangerment to the minor children. But if it's been more than 2 years, just by virtue of it being more than 2 years, you can go in on a more simple motion to modify the custody arrangement just because it's simply not working out. And there are many reasons why, people decide after they've entered a custody agreement that it's no longer working for them. Maybe the children are a little older. Maybe the parties live too far apart now to be able to effectuate reasonably the old parenting time schedule they entered. Maybe one of the parties' work schedule just really practically doesn't work anymore for purposes of picking up and dropping off the minor children. And so there are any number of different reasons and why people would want to modify a custody judgment. And if you need to get that modified, it's markedly easier to do if it's been more than 2 years. This question, however, is about what to do if somebody is simply not honoring the order. So there's been no modification. The order that you had is the order that still stands. You should file what we call a petition for rule to show cause for indirect civil contempt, or a petition for rule. That petition for rule essentially tells the court, Your Honor, you entered an order on this date. I have attached this order for you to this petition. You specifically said in this order that this and this and this was what should occur. My ex is not complying with this and this and this. Therefore, I am asking that you hold my ex in contempt of court. When you file a petition for rule to show cause, you are therefore alerting the court that one of their orders is not being followed and that the other person is in contempt of court. Now, there's definitely a process. It's much more convoluted than that, but that's the initial pleading that you should file. And then eventually, you will get a hearing on the petition for rule, where you will be able to put on your evidence. You'll be able to bring forth your witnesses. The other side, if they think that they have some legal justification for violating the order, well, they can put on their witnesses and put on their evidence, and then the court will rule. But as long as you're on the side of right and the court finds him or her to be in contempt of court, then you can do the thing that most people look forward to most, and that is to ask for the reimbursement of any attorney's fees or costs that you have expended due to their failure to comply with the order. I personally find that asking for attorney's fees, and we have a completely separate and distinct section of the attorney's fees statute that deals specifically with wrongdoing by individuals. So when you ask for these attorney's fees under Section 508 of the Illinois Family Law Statutes, you will be given every dime of money that you can show was incurred reasonably due to their breach. So what does that mean? It means that you can go out, you can hire an attorney. That attorney will do the work that he or she has been hired to do. Once they get the finding of contempt, then you can be reimbursed the attorney's fees that you spent to have to hire an attorney to come into court to enforce a lawful order. In addition to that, if somebody is found in contempt of court, they can also be punished by other methods. They can be sanctioned by other methods, including jail time for up to 6 months. Now that might sound crazy, it might sound like it's overboard. However, that's the reason why some people get arrested on failure to pay child support. I mean, there are people, quite frankly, who just disregard child support orders and they allow their child support to go unpaid for months or for years. And so if you've ever heard of somebody getting arrested for failure to pay child support, it was because they were found to be in contempt of court. But what we say in those sorts of circumstances, regardless of what the reason for the body attachment or the warrant was, those individuals, those contemptors, hold the keys to their own jail cell, meaning they are able to get themselves out of jail and they can get themselves out of trouble if they simply comply with the order. So again, filing this kind of a petition is extremely powerful, and in fact it is necessary in making sure that your rights are protected if you have an ex who is not complying with a lawful court order. I hope that this video has been helpful, and I look forward to seeing you the next time around.